thank you all for being here. While we can't be together in person, it is really honestly reassuring and heartwarming to see so many turn out for what will be an interesting and important, crucial conversation and discussion and examination of race, justice, and law. My name is Lauren Pfender, and I'm the coordinator of reference and public services at the Belmont Public Library and co-chair of Better Through Books Healing Community Together Committee, better known for most as One Book, One Belmont. I'm joined tonight by Belmont Against Racism President Catherine Bonfilio and Belmont Against Racism Board of Director member Meg Anderson in welcoming our esteemed panelists this evening. There's Renee Landers from Suffolk Law, University of Law, Raymond Wilkes, who's a legal fellow for the Northeastern Center for Racial Justice. Did I get that 100% correct? I'm hoping so. Restorative justice. Thanks, sorry. And our moderator, of course, Dovie King. Without all of you, this panel would not be possible. And it's really an excellent conversational sort of way that should be really interesting to be able to kick off these series of events. So we really appreciate all of the hard work and effort that went into making this possible. Before I introduce Dovie, I would just like to thank the Friends of the Belmont Public Library who helped to make all of these programs possible, as well as all of the rest of the library's programs throughout the year, day in and day out. I would also like to thank the many co-sponsors of One Book, One Belmont, including Belmont Against Racism, Belmont Books, the Belmont Chinese American Association, Belmont Council on Aging, Belmont Food Collaborative, the Belmont Gallery of Art, the Human Rights Commission, Belmont Public Schools, Belmont Religious Council, Belmont Wellness Coalition, the Belmont Women's Club, and of course, the Library Board of Trustees. So without further ado, let me introduce Dovie, who will be our moderator for this evening. Dovie King is an award-winning public interest lawyer committed to social justice. She draws from her personal upbringing as the daughter of immigrants in devoting her legal career to helping maintain marginalized communities. This includes representing undocumented immigrants, people of color, Spanish speakers, and survivors of domestic violence. Currently, Dovie is the director of Soar for Justice and a contributing writer for Law at the Margins. She's formerly a member of the Belmont Human Rights Commission, Town Meeting, and the Affirmative Action and Diversity Officer for the Belmont Democratic Town Committee. Dovie earned her BA in Political Science and Latin American Studies at Brown University and her JD at Northeastern University of Law. So without further ado, I'm going to let Dovie take it away.
Thank you. Hello, everyone, and thank you for joining us for tonight's panel discussion on racial justice. I would like to thank the Belmont Public Library, Belmont Against Racism, and of course, the Belmont Media Center for broadcasting this program live and also making it available online after for those who are unable to attend through Zoom. As Laura mentioned, my name is Dovie King, and I'm the moderator for tonight's program. We are joined today by an amazing lineup of speakers. We have law professor Renee Landers from Suffolk Law School and attorney Raymond Wilkes from the Civil Rights and Restorative Justice Project at Northeastern, which is my alma mater, and I'm very excited to hear from both of our speakers. Before we begin, I am going to borrow from the mission statement of Belmont Against Racism to situate this conversation. We are here tonight to foster dialogue, awareness, and understanding of institutional racism, to address the problems of injustice, however manifested, and to promote equity and inclusion. As such, our panelists will explore some of the history of civil rights legislation, as well as works of restorative justice, which unveil the human cost of racism and white supremacy in our country's history, with the goal to right historical wrongs. I will now introduce our first speaker. Please note, as Laura mentioned before, that we have reserved ample time at the end of the program for questions and answers. Therefore, I ask you to please reserve your questions or to feel free to post them in the Q&A section, and we will get to those at the end of the presentation of both of our speakers. So without further ado, it is now my pleasure to introduce Professor Renee Landers. Professor Landers teaches at Suffolk Law School. She's the faculty director of the school's Health and Biomedical Law concentration, and for the Masters of Science in Law, Life Sciences program. Professor Landers formerly served as president of the Boston Bar Association as the first woman of color in that position. Her experience further includes working in private practice and serving as Deputy General Counsel for the U.S. Department of Health and Human Services, as well as Deputy Assistant Attorney General in the Office of Policy Development at the U.S. Department of Justice during the Clinton administration. So we very much look forward to a presentation, and Professor Landers, I give the floor to you.
Thank you very much, Dovie, for that really nice introduction and a really wonderful introduction to the program. I also would like to join Dovie in thanking Lauren Pfender and the Belmont Public Library, the Belmont Media Center, and Belmont Against Racism for hosting this program tonight and this important conversation. I also want to thank my friend Joan Sobel and her friend Meg Anderson, who's the board member of Belmont Against Racism, for connecting me to this program. Even though I live only in the next town in Watertown, sometimes the distance, across the street that divides the communities can seem pretty large. So I'm really happy to be part of this program this evening. So I want to start. My presentation this evening is really in two parts. One is trying to sort of discuss some of the recent events that have sparked the national resurgence in conversation about race and racism and the systemic aspect of it in American society. Second, because I know one of the books you're reading is the book that focuses on interracial marriage. I've written a little bit about that and my own family, and I'll say a few words about that at the end of the conversation. And then obviously I'm happy to try to answer questions that people have that some of these topics will raise. I'm also very interested to hear Raymond's presentation this evening, because I think it will be a good complement to mine, because he will be talking, as I understand it, about some of the criminal justice aspects and implications of the systemic racism in our society. So I begin with a quote. As a Black person, I was actually sad. I was thinking to myself, how long do we have to be going through this? Said Latasha Brown, a co-founder of Black Voters Matter, who documented voting in a Georgia community back in the summer during the Georgia primaries on Twitter. The title of the article in which she was quoted in the New York Times was called "Bumbling by Design." And as we all may recall, back in the primaries, there was total chaos in the administration of, access to voting during that primary in Georgia. Some people waited in line until nearly 1 a.m. That day to vote for the day of the primary. Now, as we probably have all read, Georgia and many other states are proposing new laws to limit the hours of voting, limit and mail-in voting, absentee voting. And one of the proposals in Georgia, as I understand it, is to make it a crime to bring food and drink to someone who is waiting in line to vote. So we're going to have this situation of these long lines and then people not able to be sustained while they're waiting, trying to exercise their constitutional right to vote. So I've been having actually the same thought that she expressed. How long do we have to be going through this? And I've been thinking about it a lot, particularly since George Floyd was killed by Minneapolis police on May 25th. That was 290 days ago. So how long do we have to wait? 290 days. since the killing. 8 minutes, 46 seconds is a long time when a person cannot breathe because a police officer is kneeling on his neck. 6 years is a long time to wait for the reform of police departments and police practices since the killing of Michael Brown in Ferguson, Missouri. And then there are other names in recent police shootings that are all too familiar: Eric Garner, Walter Scott, Tamir Rice, Alton Sterling, Philando Castile, Stephen Clark, Breonna Taylor, Trayvon Martin. It's been 56 years since the Civil Rights Act of 1964 was enacted by Congress and signed by President Johnson. 66 years is a long time to wait for a society that is truly equal and not separate since the Supreme Court decision in Brown versus Board of Education in 1954. 157 years is a long time to wait since the 1863 Emancipation Proclamation for African Americans to be able to claim full citizenship and participation in American society. 155 years, actually I did this in the wrong order, since the 13th Amendment was adopted in 1865. 150 years, actually 52 years since 1868, when the 14th Amendment became part of the Constitution, granting equal citizenship in theory to all persons in the United States. 150 years since the 15th Amendment was adopted in 1870, establishing universal male suffrage. And 401 years is a very long time for African Americans and other people of color to have endured the legacy of slavery and racism since the Jamestown colony was established in 1619 with enslaved people from Africa. So the deaths from police violence are not just a police culture problem. They reflect the systemic racism that infects all aspects of our culture. I will talk about some of these systems, including legal rules and doctrines that have allowed such entrenched racism to pervade our culture. I also want to offer some hope that the continued reactions to the George Floyd killing mean that many white Americans and many people around the world will join us in the hard work of systemic and change. Which I think is really important. Although I read something this week that suggests that perhaps our optimism is maybe not well-founded going forward. So it's not news to anyone that the renewed public attention to police violence emerged when our lives were already disrupted and literally threatened by the COVID-19 crisis. The impact of Hurricane Katrina on healthcare in New Orleans in 2005 revealed many disparities in the healthcare system that actually are being revealed once again as a result of the COVID crisis. Two-tier systems of healthcare segregated by race and income, and that in New Orleans at the time of Hurricane Katrina the systems were not effective before the hurricane and collapsed as a result. COVID-19 has laid bare tremendous disparities throughout the economic, social, healthcare, and political infrastructures. People of color are disproportionately in jobs that cannot be performed on a remote basis. These workers perform quote unquote essential functions, but the pay does not reflect their central importance in daily life. And now we are seeing that they have no access to vaccines or not priority access to vaccinations. They must take the risk of riding public transportation and having contact with others outside their families disproportionately. Because of economic reasons, many live in more crowded conditions, not conducive to recommended social distancing or isolating or quarantining in case of illness. Environmental racism contributes to these living conditions. The location of industries and failure to enforce the environmental laws disproportionately affects communities of color. Because of economic reasons and housing segregation, many people of color are more likely to live in areas less likely to provide access to groceries and other necessities at reasonable prices. And also, as we have learned, that people of color are disproportionately affected by the COVID-19 virus crisis. I have some statistics back from the summer that at one point in the summer, 50% of the COVID-19 patients treated at at Massachusetts General Hospital were Spanish speaking. The usual hospital census for Spanish speaking patients is about 10 to 15%. And this percentage is out of over 4,000 patients. And while Black residents make up just 25% of Boston's population, they may account for as many as 40% of all COVID-19 cases in the city. And this is only, the statistics only can be measured by counting the people whose race is known. And there is a high, there's a lack of data on that point. Because of school closures, the continued educational progress of Black and Brown students has been compromised disproportionately because of a lack of access to computers and internet connections, perhaps because of work responsibilities, the inability of parents to supervise their participation in remote learning. And this insult is added to the injury of already substandard access to quality schools and educational opportunities. So I want to say a few words about some of these educational disparities and health disparities and the history of the law that has sort of created the system that we are involved in now, and then go on to talk about a few other sectors. So in 2004, and we celebrated the 50th anniversary of the Supreme Court's decision in Brown versus Board of Education. So 2014 going forward, the 60th anniversary, we're about to come upon the 70th anniversary, the landmark case that outlawed segregation in public education in the United States. The Brown decision had an immediate impact on the lives of many African Americans who were well situated to take advantage of the expansion in opportunity that the case represented. So I asked this question, why has Brown, on the one hand, had this transformative impact on the lives of people of color, of Black Americans in the United States, yet most children of color still attend schools that are not racially diverse? The broad holding of Brown was certainly adopted by society and culture, though racism still infuses all sorts of practices. The narrow holding that public schools should be integrated has failed to take hold. What accounts for this failure? So another law professor on the West Coast explains how, his name is Erwin Chemerinsky, explains how court decisions have been responsible for the resegregation of public schools. After Brown, Chemerinsky argues the federal courts became timid in actually imposing remedies that would have been effective in desegregating schools. He argues that the federal courts failed to establish rigorous timetables for achieving desegregation, did not permit inter-district remedies to promote desegregation, from the urban cores out to the suburbs, declined to identify education as a fundamental right or to mandate reform for school financing systems, and ended desegregation orders prematurely before desegregation could be firmly institutionalized in communities. And there was almost an immediate kind of recidivism after these desegregation orders ended in things like where new schools would be located, in hiring of faculty and making facilities available on an equal basis throughout communities. Justice Thurgood Marshall wrote a dissent in one of these cases, which denied these interdistrict remedies. And this is what he said: "We deal here with the right of all children, whatever their race, to an equal start in life and to an equal opportunity to reach their full potential as citizens. Those children who have been denied that right in the past deserve better than to see fences thrown up to deny them that right in the future. Our nation, I fear, will be ill-served by the court's refusal to remedy separate and unequal education. For unless our children begin to learn together, there is little hope that our people will ever learn to live together. So after that series of cases about school desegregation, the court issued a decision in 1995 that made clear that federal racial classifications had to satisfy what's known as strict scrutiny in the law, meaning that the classifications had to serve a compelling governmental interest and be narrowly tailored to further the government's interest. And so what this decision did was cast doubt on whether goals like enhancing diversity could qualify as a compelling governmental interest and therefore justify remedies for racial disparities absent proof that there was any kind of intentional discrimination, so-called intentional discrimination going on. And so it cast doubt on some of the legal principles that it supported, the Supreme Court's prior approval of affirmative action in college and university admissions, and whether these kinds of remedies would be possible going forward. And then to make clear that it was going to be very hard to overcome some of these legal doctrines to actually push forward an agenda of requiring equality in education. The Supreme Court decided a case in 2007 called Parents Involved in Community Schools versus the Seattle School District No. 1 that has made this promise of Brown even more remote to achieve. The court there held that public school districts that had not operated legally segregated schools or had operated schools found to be unitary, schools that did not segregate on the basis of race, could not choose to classify students by race and rely upon that classification in making school assignments to create diverse schools. The opinion rejected the notion, the court in the opinion rejected the notion that desegregation plans can be used to address the consequences of societal discrimination, such as racially identifiable housing patterns. And the court said that racial balancing, racial diversity, and integration are not goals that can justify the use of race in structuring remedies. The case is famous because in reaching this conclusion, Chief Justice Roberts famously wrote that, that the way to stop discrimination on the basis of race was to stop discriminating on the basis of race, as if providing remedies for racial discrimination was equivalent to some of the intentional and segregated and informal segregation practices that had occurred in the past. So it's not clear the way forward. This is just the law on the one hand promises, but on the other hand creates barriers to providing effective remedies. A similar kind of trajectory has happened in healthcare. Another scholar, David Barton Smith, published a classic work, Healthcare Divided: Race and a Healing Nation, where he described the history of racially divided healthcare in the United States. He identified 3 challenges in confronting civil rights era efforts to end disparities in healthcare. One was ending overt Jim Crow practices that segregated patients and doctors, for that matter, by race, eliminating more subtle forms of segregation based on physician referral practices, insurance status, and residential location, and assuring non-discriminatory treatment in integrated settings. His book was published about 20 years ago, and these problems still remain. His work documents that the federal government played an important but diminishing role in addressing some of these challenges. And the efforts began in 1948 with executive orders by President Harry Truman that ended racial discrimination in federal employment and segregation in the armed services. And these orders were applied to Veterans Administration hospitals and other federal facilities. And as a result, by the time the Supreme Court decided the Brown versus Board of Education case in 1954, the VA hospitals no longer provided any accommodations segregated by race. And then beginning in 1961, the Kennedy administration increasingly conditioned federal grants to medical schools and the hospitals they operated on a requirement of desegregation. Now, the vast majority of private hospitals were not subject to this federal financial pressure until the enactment of the Medicare program in 1965. For example, the Hill-Burton Act, which was earlier, provided federal matching funds for hospital construction, and the act expressly permitted the construction of racially segregated facilities. That was not a basis for denying federal funding. Now, this provision was successfully challenged after the Brown decision. Title VI of the Civil Rights Act prohibited organizations receiving federal funds from discriminating on the basis of race, color, or national origin. But the creation of the Medicare program gave the federal government the opportunity really to bring serious enforcement using Title VI of the Civil Rights Act against hospitals and in other contexts where discrimination continued. Hospitals were now pressured to desegregate in order to receive federal funds. Hospitals had the choice really of continuing to pursue their segregation practices or court bankruptcy because of the absence of the inability to accept Medicare funding. So within 4 months after the Medicare program was created, more than 1,000 hospitals integrated their medical staffs, waiting rooms, and hospital floors. Integration of blood supplies and hospital room assignments followed. So since that period in the middle of the last century, when the federal government led the effort to desegregate hospitals, civil rights enforcement actions in healthcare settings have been somewhat sporadic and anemic. After ending the most obvious forms of discrimination by outlawing segregated facilities and services, the forms of discrimination became more subtle. Certain legal interpretations of the civil rights laws also made pursuing violations more difficult. For example, in 1963, the Department of Health, Education, and Welfare exempted physicians participating in the Medicare program from complying with Title VI in their private practices. Part B of the Medicare program, which covers physician services, was defined as a contract for insurance between the beneficiary and the government instead of a direct grant of federal funds to the physician. Now, recently, as part of the Affordable Care Act, Congress has broadened the scope of the anti-discrimination provisions that apply of the laws that apply to healthcare, and so there may be renewed ability to take some actions to address some of these deficits in the prior law. And then there was another Supreme Court decision that set up another barrier because the Supreme Court ruled in a case in 2001 that individual private litigants could not bring lawsuits alleging disparate impact on facially neutral policies. If there was a facially neutral policy that actually had a racially disparate impact, the only enforcement opportunity under that case would be for the government to bring an enforcement action, which obviously greatly reduces the opportunities for challenges to some of these practices. And so, I could go on in other areas, and I know that I'm going to run out of my time, but in the voting area, I think many people who've been paying attention really are aware of the Supreme Court's decision in Shelby County, Alabama v. Holder, which was a case in which the court found that Section 4 of the Civil Rights Act, which required states and communities, jurisdictions to obtain pre-clearance for changes in voting laws and practices was unconstitutional. So that means that all of these laws that are being proposed in states where people are unhappy with the results of the 2020 presidential election, formerly in states like Georgia, would have had to seek approval for these changes in voting practices before they could be put in place. Now, the only remedy is to sue after perhaps people vote. The remedy is really going to be retrospective and not prospective. So this is, a new challenge to trying to enforce equal voting rights. In the housing discrimination area, there is a 2017 book by Richard Rothstein called The Color of Law, A Forgotten History of How Our Government Segregated America. He discusses how decades of local, state, and federal housing policies mandated segregation, created a racial and cultural divide, and that these divides continue to have enormous and lasting impacts on American society today. The segregation of the metropolitan areas, he says in the book, leads to stagnant inequality. For example, just a few examples that he documents, the Veterans Administration rejected applications from African-American veterans for mortgage assistance. Restrictive covenants were enforced by courts. And because of the inability to acquire, real estate at the same level, this has been a barrier to the accumulation of wealth among communities of color. And this brings me to really my last point. Dollars are like air, crucial to vitality. Having less can cost more. Black students borrow more money to go to college because of other issues and this inability to afford college, do not graduate as often and struggle more with student debt. The same is true for Hispanic students and Latino students. Then this is a cascading effect on the rest of their lives. They earn less, thus perhaps leading to lower credit scores. They pay higher interest rates for purchasing homes, cars, appliances. It's hard for them to buy a house or to save for retirement, so they leave less to the next generation when they depart the earth. I won't go through all the statistics about the wealth and income gaps, but some of the gaps are the widest, historically the widest that they've been since these things have been measured. For example, the home ownership gap by race is the widest in 50 years. All of these factors have led to the crises in healthcare and policing that we currently face. At this moment, one can become weary about the conversations that we continue to have. This is the quote, that I started the talk with. But on the other hand, not to minimize the human suffering that has gone on because of COVID and the crisis of police violence. One really cannot waste a good crisis, and now we have two at the same time that give us an opportunity to really try to make progress on some of these issues. I don't mean to be flip, but the time to achieve legislative and institutional change is when events cause people to pay attention. The one doubt that I will cast into this is that Charles Blow had a column in the New York Times earlier this week, where he talked about some recent polling numbers that are concerning, that the moment of crisis may have passed, and maybe diminishing some of the opportunities for reform that seemed very promising in the summer. He said that there was a USA Today poll that was released at the end of last week that found that just 28% of white Americans believe that what happened to George Floyd was murder, which was down from 55% in June. And so this is the, and then, to sort of add insult to injury and, perhaps reflecting that change in sensibility, he noted that Republican legislators in Florida and 21 other states are considering new penalties for protesters who break laws. The bills would prevent localities from cutting police budgets and give some legal protection to people who injure protesters. So the public opinion in some ways has started to shift in a way that will make it more challenging for reform. So I would say that we've been waiting a long time to engage America in making the values real. Confederate statutes are coming down. 2 branches of the military have banned displaying the Confederate flag. The Army is floating the idea of renaming military bases that were named for Confederate generals. There are 11 or 12 of them. My father was a career enlisted man in the Army, and he served at 3. He's black. He was black. Fort Benning, Fort Bragg, Fort Hood. Honestly, what kind of country names government facilities after traitors? NASCAR even is banning the Confederate flag. So perhaps if we all do our jobs as lawyers and citizens, perhaps my son, who's 25, about to turn 26, will be able to see a transformation in his lifetime. And maybe I know that I'm probably right at the end of my time. So I'll just, say a couple of words about interracial marriage, which I didn't address more generally in deference to the book that is one of the community reads that Belmont has identified for this season. I was born in Springfield, Illinois, to a white mother and a black father. And except for the 3 years that my family lived in Germany, we lived in a transitional neighborhood where Abraham Lincoln lived when he was elected president. Railroad tracks at 10th Street separated the neighborhood from the center of town, which is determined by the old state Capitol building where Lincoln delivered the House Divided speech, which is now a national historic monument operated by the Park Service. During my youth, the neighborhood was an integrated neighborhood of middle-class white and black residents, but eventually became a black neighborhood comprised of families of more fragile economic status. When I was about 10, an African-American playmate whose family was relatively new to Springfield asked whether it was illegal for my parents to be married. I was surprised to discover my own sense that I would be expected to defend my parents' marriage, even as I was developing my own sense of racial identity and coming to terms with the racial identities assigned to me by others. And so that first childhood encounter with other people's views of racial identity, of the racial identity of my family, illustrates both the liberating and limiting impacts of law in shaping the lived experiences of families formed through interracial marriages. Today, as an adult and lawyer, I have the tools to reflect on the transformative impact of the Supreme Court's decision in Loving v. Virginia, which said that laws banning interracial marriage were unconstitutional, and these other civil rights cases, some of which I previously discussed. And so all of these legal changes have enabled me to make certain life choices such as where to go to school, where to live, where to eat and shop, and who to marry on the same basis that other Americans had long taken for granted. But while Loving gave the imprimatur of the legal establishment to the concept of interracial marriage, my conversation with that childhood neighbor and other personal experiences illustrate that legal recognition is not sufficient to alter settled societal expectations and practices. However valuable societal approval may be, it cannot substitute for the concrete entitlements that only law can convey, but law alone will not change the way in which society deals with aspects of race. It's work that we all have to engage in on a daily basis. So thank you for your attention, and I look forward to your questions.
Thank you, Professor Landers, for that informative presentation, especially for discussing some of the challenges and milestones with regard to desegregation efforts in education and in healthcare, discussing housing and voting and interracial marriage. So I look forward to a discussion later on in our Q&A period regarding some of these topics that you addressed. And with that, I would like to introduce our next speaker. Our next speaker is Attorney Raymond Wilkes. I don't know if we have a visual up yet, but Mr. Wilkes is currently a legal fellow at the Civil Rights and Restorative Justice Project of Northeastern University School of Law. The project that he works on conducts research and supports policy initiatives on anti-civil rights violence in the United States and other injustices during the period specifically between 1930 and 1970. Mr. Wilkes manages the project's cases and supervises its student investigators. His work includes conducting police trainings, supervising attorney investigators, and fostering partnerships with other civil rights organizations. Additionally, Mr. Wilkes serves as an advisor to Northeastern University's Restorative and Transformative Justice Task Force. He's an adjunct professor at the Southern University Law Center. And with that, I would like to give the floor to Attorney Raymond Wilkes.
Thank you, Attorney King, for that. I also want to give my thanks to the entire Belmont team for the work that they are doing. It is truly amazing work seeing what you're doing for your community. I also want to thank Professor Landers for her amazing presentation and providing the backdrop and the necessary legal perspective to understand what was going on in this period. But as Attorney King stated, yes, I work for the Civil Rights and Restorative Justice Project at Northeastern University School of Law in Boston, Massachusetts. Though a lot of people ask me, what is the Civil Rights and Restorative Justice Project? What really is the work that y'all do? And with that, I generally ask them a question, which is, have you heard of the case of Emmett Till? 9 times out of 10, people say, yes, I have heard of the case of Emmett Till, the young 14-year-old boy who was lynched by 2 white men in Mississippi in 1955. I say, okay, that's great. Well, have you heard of the case of Charles Moore and Henry D. in Mississippi? Crispin Charles in New Orleans? George Floyd, not of 2020, but of 1945 in Florida? Austin Calloway of Georgia? Or Amos Starr of Alabama? And the answer to those questions 9 times out of 10 is no. And the truth is that there are hundreds, if not thousands, of Emmett Tills within American history throughout the Jim Crow era, the period of 1930 to 1970, within the southern and southern border states of this country. And that is what CRJ is here for, to ensure that this truth is noted and documented. And so our mission is that we are a program of interdisciplinary teaching, research, and policy analysis on race, history, and criminal justice. We investigate these incidents of racially motivated homicides within the United States during the Jim Crow era, and try to obtain justice for those families via the criminal route or restorative justice, which we will discuss later on. Though what we also are doing is, with the cases that we investigate, we are building an archive and plan to release the archive to the public. It is titled the Burnham Nobles Digital Archive. It is titled in honor of our two founders. The first being our current director, Professor Margaret Burnham of Northeastern University School of Law. The second being Dean Melissa Nobles of the Massachusetts Institute of Technology. And third, what we're doing with these cases and the archive that we're building is we're looking at these trends from these cases, right? Because again, we've been in existence for over a decade. And one of these trends and lessons learned, we are now creating programs and holding conferences and creating various projects and furthering our mission. Examples of this include in fall of 2020, I was about to say 2019. This year has been a little long with the pandemic, but in fall of 2020, we actually held a conference regarding reparations for the descendants of lynching victims, in which we were able to have academics and scholars from across the country, and more specifically, the descendants of those lynching victims present to determine how best to obtain reparations for this class of people. We are also creating podcasts currently right now with students and graduate students to make sure that this history is never forgotten. And we have also created a police training, Historical Injustices and Present Policing, in which we really begin to talk to the police departments and get them to understand where this level of distrust between African American communities and the police began and how to mend these relationships through restorative justice. And so now, since I've talked about our collective work and everything, I really want to get through and talk about one specific case, a case that I feel embodies the violence that took place during the Jim Crow era. And that really shows the arc of what CRJ is able to do for the community and how restorative justice is needed. And that is the case of Henry Pegg Gilbert. Henry Pegg Gilbert lived in Harris County, Georgia in 1947. He was a father to 4 young girls, a husband to May Gilbert, and he was a relatively wealthy man. And I say relatively wealthy in that he owned 100 acres of land in Harris County, rural Georgia, in 1947, which is very rare for African Americans during this period. However, before I get to the date of question of May 19th, I need to back up a couple of days before this in the month of May of that same year. And that is with Gus Davidson, a 27-year-old Black man. Davidson was driving down the road when he hit a young calf owned by a white farmer, Olin Sands. Olin Sands then confronted Gus Davidson. Now, our records don't say exactly what transpired as to who said what or who pulled out a weapon first. But what we do know is that Gus Davidson shot Mr. Sands in self-defense. At that point, he fled. He tried to leave town. And people may wonder, why was he trying to leave town? The answer is simple. It was rural Georgia in 1947, and he knew that the law was not going to be on his side. And sadly, he was correct. The sheriff arrived on the scene and a white mob formed. And that white armed mob, led by the sheriffs, searched throughout the area in search of Gus Davidson. Days later, early in the morning at 3 a.m., the Gilbert family gets a knock on their door, and it's the police. At 3 a.m., they arrest Henry Pegg Gilbert and charge him with aiding and abetting Gus Davidson. Now, our records show no evidence that the Gilbert family and the Davidson family were close with one another in the sense that they would harbor and protect Gus Davidson. Nor do we see that the Gilbert family and David family knew each other that well in general. But again, during this era, that wasn't needed to make an arrest, sadly. The police brought Henry Pegg Gilbert to jail. May Gilbert sent her brother to check on Henry Pegg Gilbert. Her brother was unable to see Mr. Gilbert. When he was at the jail, Henry shouted out to him, saying, "There's no use. I'm never leaving." Sadly, he was right. Within a day or two, May Gilbert was notified that her husband was dead. The FBI investigated the case, which isn't always the case within our cases that we've come to find, but they did investigate the case, and Harris County Police Chief Buchanan claimed that he went to see Gilbert in the interrogation room to try to get a written confession out of him. When he entered in the room, Gilbert tacked him, threw a chair at him, and then tried to gouge out his eyes. The chief stated that he had no other option, and as a scuffle ensued, that he had no other option but to shoot Gilbert in self-defense. Now, while we understand that there's no record disputing the fact, the issue becomes the amount of injuries that Henry Peg Gilbert explained. So the record shows that Henry Peg Gilbert had a broken leg, a crushed skull, a beaten face, and 6 bullet wounds scattered throughout his body. So those injuries don't necessarily match up with the statement of Chief Buchanan. However, the FBI believed the police, and no charges were pressed against the officers. Though some may ask, what happened to Gus Davidson? And the irony is that Gus Davidson had escaped. He was in Camden, New Jersey this entire time, and he created a new life for himself. Eventually, he was caught. He was brought back to Georgia in 1951 and stood trial. He was sentenced to death via electric chair. However, his sentence was commuted to life imprisonment. 9 years later, he was paroled, and he died at the age of 77 in Georgia in 1966. So first, what are some lessons that we as a society can learn from the case of Henry Peg Gilbert and from the many cases that we have amassed in our Burnham Nobles Digital Archive? The first is that this tells us what has happened to many African American men or African Americans who succeeded in the Jim Crow South, right? We see that Black men in particular who owned property, amassed wealth, had businesses, their white neighbors became jealous of them, and rumors spread, and they brought those rumors to officers. And like Henry Peg Gilbert, they were arrested, and they eventually died. Though next, this case also demonstrates a trend of the legal aftermath in these cases. It's the fact that there was no sense of justice the criminal justice system or even the civil system could provide to these families and victims. So in the case of Henry Peg Gilbert, as I stated before, charges were not brought against the officers. The FBI, although current day, looking at the statements and compared to what took place, although it doesn't make sense, they believe the officers and they closed the case. Though even still, what is more amazing is the fact that after a police chief shot a man in custody within the prison 5 times, there was no internal investigation. That was the justice afforded African Americans during the Jim Crow era. Third, this case tells a story of the violence that African Americans endured. And so what happened to the Gilbert family? Well, May Gilbert buried her husband. She stated at the funeral that kissing her husband's head was like kissing a sack full of broken little bones. Sadly, no more than days after burying her husband, the police charged her with aiding and abetting Davidson to escape. No evidence of it, except the rumors that were swirling. Thankfully, a young white attorney was able to help her, and she was able to get those charges dismissed. However, she did not stay in Georgia. She and her family, she packed their belongings and she moved to Detroit, leaving behind their 100 acres of land. So then what happened to these 100 acres of land? It was sold at public auction, and guess who bought the land? The Sands family. Yes, the family of the farmer Olin Sands, where this initial incident started. And so this case also explains and shows and highlights that millions of African Americans, just like the Gilbert family, fled from the South. They fled for safety and fear of retaliation. And then finally, this case teaches us about historical and intergenerational trauma. So quickly to review, intergenerational trauma is trauma passed down from one generation to the next. Historical trauma is trauma from histories of violence or oppression that result in a shared experience of an entire population. As Professor Landers talked about, with New Orleans, there is the historical trauma within the city of New Orleans for hurricanes that people have experienced, right? In the same token, there is historical trauma within these minority communities, within the African American community, based upon the incidents that took place. And the same can be said for the communities in which these incidents took place. Though if you look at the family, there's trauma that is passed down from generations, especially within the Gilbert family. So we know that both the mother and the daughters had trauma, right? Having to see their father, their husband at the funeral in the state that he was in, having to flee their home out of fear. That's trauma inducing. Though in our work, we try to connect with the families to see how we can provide justice to them. And so, in contacting the family, we were able to contact Henry Peg Gilbert's granddaughter. Surprisingly to some, but something we also find in our case is that she never heard about this incident. Her mother, her grandmother, her aunts, no one ever told her why they moved to the north and what happened to her grandfather. Though, upon finding out, a light bulb went off. It was as if everything made sense. She now understood why her mother acted the way she did, why she raised her the way she did. She now understood why her family reacted and did the things that they did. And so, what that goes to show you is that although the family may not speak of the trauma, may not speak of the incident, it still affects future generations, right? And again, just as I said before, just as there are hundreds of Emmett Tills, there are hundreds, if not thousands, of Gilbert families throughout this country. So then the question becomes, what can we do today to remedy these historical harms? People usually think, go to court. Why not try to get charges pressed against these people? Why not try to sue them to attain some form of justice? But you have to remember, for a successful case, you need evidence, you need witnesses, right? And in these cases, these incidents took place in the 1930s, 1940s, and the perpetrators have passed away, those who have caused the harm. There's no longer any evidence to bring to trial, along with the fact that there's a statute of limitations in which you only have a set amount of time from knowing about the incident to bring a case. So this means that we have to look towards alternative avenues for these families, alternative forms of justice to restore the family. And this is where restorative justice comes into play. For CRJ, we view restorative justice as a process in which the affected parties come together to acknowledge a harm and take steps to provide reconciliation for the victims, their families, and their communities. In our case, the harm is a historical one, but the extensions of the parties involved are still around today. For example, the Gilbert family. Although Henry Peg Gilbert is no longer with us, nor is May Gilbert, their descendants, their grandchildren are present. And while Chief Buchanan of the Harris County Police Department is no longer with us, or the sheriffs or other officers involved, that department, that institution is present. Therefore, they need to come together and amend the harm. And this has been done with this case. So then people ask, what are some examples of restorative justice? How can we take steps to begin the reconciliation process? And at CRJ, we believe that one of the steps that can take place is engaging public officials and obtaining official apologies. That was done in the Henry Peg Gilbert case. There, the grandchildren came back to Harris County, and then Harris County Sheriff stood in front of the congregation at the church and acknowledged the wrong that his institution, the sheriff's office, played in killing their grandfather and apologized for the incident. The other thing that can take place is engaging the families of the perpetrators. This doesn't always happen, but we are amazed when it does and we're able to achieve this. This also happened in the case of Henry Peg Gilbert. The granddaughter of County Sheriff Brennan, who played a role in Gilbert's death, she reached out and apologized to the Gilbert family, specifically Henry Peg Gilbert's daughter, for the role that her family played in this. The other form of restorative justice that we find that can take place are creating burial markers and civil rights markers. We were able to do this with one of our cases in Louisiana, specifically Gretna, Louisiana, and that was of Royal Sarah Brooks. a husband and father of 3 who was shot in downtown Gretna by a police officer, all starting from a dispute over a bus fare that was no more than 5 cents. We were able to establish an historical marker at the site where the bus was at, the bus stop at that period of 1947. Another thing that we're able to do are to hold commemorative events and exhibits. And so we were able to do it, of course, with the Henry Peg Gilbert case, but also with the case of Royal Soar Brooks. And with Royal Soar Brooks, what even made it more amazing was the fact that the mayor, the then mayor of the city of Gretna, Louisiana, came to the ceremony, apologized on behalf of the city, and issued a proclamation stating what happened should never have been happened to their loved one. We also believe in doing something that people deem to be very small, which is correcting public records. But the truth is that this work is that of truth telling. And truth telling means ensuring that the history reflects the truth. And that means going back and fixing these public records and changing the death certificate from saying that the victim was killed via accident to the fact that it was an actual homicide. Another thing that we do, again, if the evidence is there, we are happy to work with the family in bringing in action, but that isn't always the case. But we also are able to provide consultations. In 2016, we sponsored a congressional briefing on the Emmett Till Civil Rights Cold Case Act in Washington, in which we gave members of Congress an opportunity to hear firsthand from family members of victims whose cases were brought to light for the first time by the Civil Rights and Restorative Justice Project. And so in sum, these historical harms perpetrated and continued by white supremacy throughout the Jim Crow era, they traumatize these families to the point that, as one descendant stated, it's not fair. It's not fair that my father had to tell me that my grandfather was killed due to racial violence, due to the hands of police. It's not fair that I now have to tell my children that their great grandfather was killed, and they have to tell that to their children and their children. It's not fair that it's now become a part of our family history. And what restorative justice does, it does not unlynch the victim. It does not change the chapter or move the chapter from the book of that family's life story. But what it does is it adds an additional chapter such that the family doesn't have to simply state that my grandfather, my father, my grandmother was lynched and killed at the hands of racial violence. But it ends with the fact that these institutions that played a part in this harm came, acknowledged, and apologized, and are taking steps to remediate this harm. But to these same institutions, it has to be noted that restorative justice is not a program. It is not a one-time thing that you do to where you show up at the church, make the apology, and go back to your offices. It's not something that you do with a community outreach and then post it on your website, right? Restorative justice is a philosophy. It's a way of living. It requires structural and systematic changes to take place to further show that you are taking steps to remediate this harm. And in summary, that is the civil rights and restorative justice. And that is the work that we do. Thank you.
Thank you, Attorney Wilkes, for that very eye-opening presentation, and for sharing the incredible work that the project is doing, as well as the movement for reparations. And we're going to open it up now for questions and answers from the public. But I would like to start the conversation by posing a question to you. So the work that the project is doing is really giving a human face or dimension to lynching and violence perpetrated against the African American community. Could you explain to the public why it's important to document this type of violence against African Americans? Like what can be achieved by doing that?
Well, I think the first thing to note is that this is American history, right? I think that's the issue that some people have to understand, is the fact that this history should have been documented, just as we've documented various other acts throughout history. But at the same token, those who don't understand their history are doomed to repeat it. And as you heard before, people always hear of George Floyd, but what they don't know is that our cases show that there was a George Floyd in 1945 in St. Augustine, Florida, who was beaten by police officers. Imagine if that history was noted, if those departments had known of this history, taken the lessons from that, we wouldn't have another George Floyd. We may not have had another Mike Brown, another Trayvon Martin, and the list goes on and on. So first is the fact that this history is American history. And second, we'll be having these same panels and same conversations if we do not document this history.
Thank you so much. At this time, please feel free to continue posting questions in the Q&A section. I do see one question for Professor Landers. See if I can get that. If we have Professor Landers, there's a question for you. The comment is racism has been described as a public health crisis. Are there any legal avenues to address this? How do we address racism as a public health crisis? Are there any legal remedies, Professor Landers?
So I think that the remedies for the problem with the public health crisis and the contribution that race has made to it is a really broad solution. It's not just kind of a one side, one fix, as Professor Wilkes was talking about. It's not just, kind of a one, you change the law and then everything will be fine. I think that what really needs to happen is a whole panoply of changes in the way we organize our society. I would say, I know that we have a little competition right now at this hour with the president's speech, but for this program, but what I would say is that the pandemic relief bill does offer some steps for beginning to make the change. I think the idea that families should receive support so that they have sufficient incomes to raise their children in really healthy and circumstances is a really important transformation that is reflected in the pandemic relief bill with these expansions of the earned income tax credit and direct payments to families who have suffered during the pandemic crisis. So one of the things that's very clear is that not having enough money is kind of a public health crisis in and of itself. Enough money to buy food, to have a decent place to live, and not to have to work yourself into a grave where you never see your children. All of these things are really important. And so, whether it's, making sure that people are adequately, get wages, earn wages that adequately compensate them for the work that they do, that we have, housing laws, adequate access to housing, that people have sufficient incomes, to raise their children and have access to healthcare. All of these things, it's really this broad panoply of social interventions that has to happen. And I think that one of the other, in addition to the public health disparities that were revealed in the COVID-19 crisis, were the weaknesses in the social insurance infrastructure in the country. And by social insurance, I mean things like the unemployment compensation system, the workers' compensation system, and and then we could even get into the weaknesses in the Social Security retirement system as well. And these programs have suffered from a lack of intention over the last several decades, so that they were really not ready to step up to the plate in real time. I mean, they did, it was better to have them than not have them, but there were certain weaknesses that need to be addressed. And just as we need to invest more in our public health infrastructure and our infrastructure of roads and bridges, we need to re-examine the infrastructure for those programs as well, so that they actually work when they're needed.
Okay, thank you. We have one question addressed to Attorney Wilkes regarding how difficult is it to actually research, the type of work that the project does. Maybe you could describe some of the sources, the records that you look to, and where you find information about racial injustice perpetrated in the past.
Yes, it can be very challenging. Again, our record keepers in this country were not accurate with African American histories. And this is something that is being addressed now. I believe in the past couple of months, the Alabama State Archives has released a statement noting their role in perpetuating white supremacy by not being accurate keepers of its citizens' African American history. And so that just goes to show you the steps that are currently being taken, but it can be difficult. And
Yeah.
with that, it's a matter of a lot of times our records come from files from the Department of Justice, the FBI files, their investigation files, to where they may deem a case closed, but us further looking into the case shows that this case should not have been closed. But at the same token, you also have to remind yourself, what were the law on the books that these officers could have been even charged with, right? And would the courts have allowed that to even mitigate itself up through the court system? So that's another situation. But DOJ records, FBI records, it can be also challenging as sometimes, ancestry finding census records, as even census keepers were not accurate in how they spelled and the ages they gave to these victims. These are where we see the trends of assigning Black men who are young, older ages, and things of that nature as well. But at the same token, even in light of all of this, our archive has, I want to say, we've identified over 1,000 cases of racially motivated violence within this Jim Crow era. And to some, that may seem like a lot. But the truth is that NAACP records show that I want to say from the late 19th to early 20th century, there are over 3,000 lynchings of African Americans. So in truth, while our 1,000 cases appear to be a lot, it's really just the tip of the iceberg and the tip of understanding what took place throughout this period and how America came to be.
Okay, thank you. So it looks like we have someone who from the audience who wanted to pose a live question. I think that would be fine. Let's see if we can get that person's question.
So Brianna, if you wanted to ask your question, I know you had raised your hand probably partway through Attorney Wilkes's talk, but feel free to unmute.
Thanks, Lauren.
Hello.
Hello.
Can you hear me?
Yeah.
Okay. Well, when I initially raised my hand, that was an accident. But as I listened through Attorney Wilkes' presentation, I did have a question and I did want to ask him if you are interested in restorative justice. I know myself, I've had family members who've indicated things that people have died in police custody and things of that nature. So if someone wants to start with restorative justice, how would you say that they even start? Like, where does one begin?
Well, I think the first thing is trying to understand what took place in the incident. I think preparing yourself and knowing the true entire history allows you to know all the parties that need to be involved in this healing process, right? Because restorative justice revolves the parties who endured the harm and the parties who caused the harm, right? So those who endure the harm are those persons, one, who may have been beaten, and their family members. But at the same token, restorative justice is truly centered in the community, such that this harm not only affected that family, but it also affected the community as a whole. So they need to be involved in this. And this could be as simple as, in the case of these incidents, of approaching your legislators, your governing officials, mayors, and so forth and so on, and talking about the incident, showing the records, the documentation of what took place, and getting the word out about it. A lot of times it is a sense of protesting, the sense of having to where if government officials don't respond, of getting the word out, letting it be known, and having the public support behind you. Again, the community support to know that this incident took place and we need to find means to restore this. But also just to notice restorative justice is used for historical harms and present day harms. So I would really urge everybody to look out and to see if your community actually has centers, restorative justice community centers that are working with current day harms, be it persons who are charged and finding alternative forms of justice. So that would be my thing to start, is truly understanding the history and then reaching out to those persons that can affect the change, be it your government body officials and the community at large.
Okay. Thank you for that. We have a question that would be addressed to Professor Landers. The question would be the role of grassroots participation and organization in terms of influencing the law. What do you see the role of just grassroots organization in terms of propelling the civil rights movement forward, or is that a way that we could affect change in the future?
Well, I think so. And I think it's sort of partially reading the question a little bit as well. There is a role. I think the question stems from my comments about how sometimes the courts have not been sufficiently, committed to, continuing to advance the cause of racial justice, and through the evolution of legal doctrines, and so that problem is going to be there. But I think that the important thing is to for people to participate in their communities, to vote, and to participate in these grassroots efforts, because if you can influence legislatures to change laws, or governments to change policies, that will set a baseline, and that we can't be totally reliant on the courts to protect rights. That we have to actually take some responsibility for that ourselves. That said, when thinking about how you vote, think about the kinds of people who will be appointed judges. In Massachusetts, we happen to live in a state which does not have elected judges. Other parts of the country, they can think about who the people are that get elected to judicial positions, as well as all the other positions that we're used to voting for here. So I do think that is an important. It establishes an important pressure point on change.
Thank you, Professor. And I see one question that would be directed to Attorney Wilkes regarding the significance of an apology. There may not be a mechanism to formally right a historical wrong, but what is your take in terms of how far would an apology go, or acknowledgement of a wrong that was committed in the past?
Well, I think, again, the acknowledging and apologizing are just the initial step that really has to take place. And that's something that we tell a lot of times with the police departments that we work with, is the fact that, yes, we're happy that you're willing to work the community if there was a wrong, to acknowledge and apologize for it, but what are you going to do to follow up on this? It's kind of like, telling your children, when they do a harm or create a harm, yes, you should say that you're sorry, but what are you going to do to ensure this doesn't happen again? And I think those are conversations that these institutions need to have with the community, to review their inner workings, to see how did this happen, and how can we ensure this doesn't happen again, and how can we better help our community as to repair any harm that has come from such incidents.
Can I say something in response to that question as well? Because this idea of the apology and then trying to change practices going forward is something that is a new idea in healthcare right now as well. The issue of medical malpractice. There's a lot of growing literature about the importance of when mistakes are made, and mistakes do happen, that the importance of the medical professionals, the healthcare institution, hospital, whatever, acknowledging the mistake, having an honest conversation with the patient's family about the mistake, and that sometimes that is very satisfying to the patients, because the acknowledgement that something that happened that should not have happened, or something that should have happened didn't happen, and that's a very important acknowledgement to make. I actually had the privilege of working for the United States Department of Health and Human Services. I'm not going to get the exact year correctly, but in the late 1990s, when President Clinton offered an official apology to the men who were abused in the Tuskegee syphilis experiment, and brought the surviving a group of men to the White House, and had a offered the official apology of the United States government for the harm that was a government-funded research project that was done to them, and the disruption to their lives. Their families were invited as well. And I think that this recognition really spurred the government regulators of that regulate and are supposed to protect the human subjects of healthcare research from these kinds of abuses, really sparked a reexamination and a strengthening of those policies and those oversights, and actually has also led to the increasing efforts to include more diverse populations in clinical trials for drugs and treatments, which had not been the routine before. And so I think that these movements and changes will go a long way to addressing some of the lack of trust that people of color have exhibited in the healthcare system, and that's leading to some of the vaccine hesitancy that we're seeing now, in reaction to the COVID-19 vaccines. But I do think, I do have the confidence that the clinical trials that were done on the vaccine included diverse populations. They included far more people than are typically included in vaccine trials. And so the vaccine is actually very safe, but there is this the vaccines are safe, but there is this history of distrust to overcome stemming from events like Tuskegee. But I think the apology, as Attorney Wilkes said, is the starting point to real systematic change.
Thank you for that, Professor. So we have a few minutes left before we conclude the program. And so there's one question that is addressed to Attorney Wilkes regarding, you mentioned the white mob mentality and approach to justice. Like how do you relate that approach to the current Black Lives Matters movement?
I think it was Blue Lives Matters on that one.
Oh, sorry.
Yeah.
Okay, Blue Lives Matters.
Well, I will say my work with police officers has greatly expanded my knowledge and understanding of what their role really entails. And I feel that for us to move forward, there has to be an acknowledgement on both sides. And I feel like on my side with these community members, it's a matter of acknowledging really what a police officer goes through. Many people don't know that there are a great deal of issues within police officers in these departments. Mental health concerns are on the rise. Suicide is on the rise within police officers in the police departments. Many people don't realize that an officer coming to the scene is the medic, counselor, therapist, protector all at once. And that's a lot to deal with and have to take home, right? And so there's an acknowledgement of that has to take place. And as I've found, acknowledging what they go through and thanking them for the work that they do and that they chose this position, it allows them to hear what we have to say about the issues going on with the communities that we're working with. But at the same token, the issue with the Blue Lives Matter compared to the Black Lives Matter is that there is not a legacy of violence on the individual and systematic level that we see within the African American community and the same level as within police departments, as due to even how police departments were established within this country. So that would be my response, is that I can understand their concerns and their job does require a lot and their work is valued and needed, but I can't weigh it the same as the generations and legacy of violence that African Americans and other minority groups have endured throughout this country. at the hands of the government, which police officers and departments are a part of. And as it relates to the white mob, I think that just goes to show where a lot of the concerns and fears are regarding these incidents. With the riots at the Capitol, I think it was amazing to hear the different responses because communities of color were not surprised. You know, again, our work kind of highlights the fact that people say that, oh, these are just stories that are being told throughout generation. And it's just like, no, our work shows that these were actually incidents that became a part of the Black experience, the Black history, the historical trauma that we as a people carry. And so I think that just goes to show that also is that it's not too much of a surprise to our communities, but yeah, those are my responses.
Okay, thank you so much. I want to thank everyone out in the public who participated in tonight's program, and both of our speakers tonight, Professor Landers and Attorney Wilkes, for their very